this will be a great chance to bring Josh in right now.
Yeah. Hey, Josh.
Josh, how unusual is this now? I mean, this jury was so intimately familiar with this case. Now they have to start over? Not on the conviction, but on the next phase.
Can I kind of go through some of the drama that happened this week?
Absolutely. Lay it out for us.
So, just for the viewers to, just kind of catch up what happened. So, earlier this week, the judge unilaterally dismissed one of the jurors. And this is unusual because, generally speaking, a juror is dismissed after a judge collaborates with the prosecutor and the defense attorney. So if a juror does something that they're not supposed to do, a judge will bring it to the attention of the prosecutor and the defense attorney, and then there will be arguments about whether or not the juror should be dismissed or not, and then the judge will decide. But here, it's reported that the judge just dismissed the juror without even asking the opinion of either one of the prosecutor or the defense attorney. So it had to have been so extraordinary what this juror did that the judge was like, I have to do this. So the judge brought on an alternate, and that alternate came on to the jury and deliberated with the panel yesterday. And we all know what happened yesterday, and this was not to the benefit of the prosecutor. So the alternate juror did not help the prosecution. And yesterday, around 2 o'clock, the judge received a note from a juror saying that they were at an impasse. There was just a 2-line note saying that they could not find any resolution in the case, that they could not agree on a verdict. And the judge brought in the prosecution and the defense, and the defense said that this should be a mistrial. And the judge said, well, I'm going to send the jury back in there to deliberate. And the defense is like, well, hold on, Judge. If you do that, that's coercion, because the jury has already made their decision, and if you do that, you're telling them that they've made the wrong choice, and you're inserting yourself into the deliberative process, and that's an appealable issue. And the judge then declared a mistrial about an hour later. So I think that the judge took that to heart and made the correct decision, because what you don't want is for the jury to then find for the death penalty and then for it to get overturned by the Supreme Court later on. So the judge declared a mistrial, and now we're at the point where the prosecution has to decide whether or not it's going to go for the death penalty again. Now, in Arizona, the prosecution gets 2 attempts at the death penalty. Now, we've seen this before in another famous case, the Jody Arias case. Yes. Where, Juan Martinez, the famous prosecutor from Maricopa County, he went for the death penalty for a second time, and it took about 17 months to go from the first death penalty phase, where it was a mistrial, to the second death penalty phase, where it was also a mistrial. So it was a long time between the first death penalty trial to the second death penalty trial. But it was also a lot higher profile. But it can take a long time between the first trial and the second trial. But here, I would expect that it's probably going to happen a little bit faster. There is a status conference in a couple weeks where I would expect that the court will set a second trial relatively quickly if the Maricopa County Attorney's Office does decide to do a second trial, but they haven't indicated yet whether or not they're going to do that.
So when you say they start again, they start over, how much of that process is rehashed?
It's a long process. They're going to have to do another death panel certified jury, and that can take...
Choosing a whole new jury.
Yes.
What does death panel certified mean?
It means another 6 to 8 weeks of choosing a jury that can be fair and impartial for just the death penalty phase of that this trial.
But
right?
hold on one second, Josh. It sounds to me like somebody is philosophically opposed to the death penalty.
Yeah, so they need to
Aren't
weed
they
out
supposed
those
to weed
people.
those kind of people out?
They are. And that's why this is so difficult. Because let's say that somebody was on the panel yesterday and they were like, look, I just can't issue the death penalty or vote on the death penalty because I'm against the death penalty. That person should not be on that panel because they took an oath to set aside any personal bias and to be open-minded to vote for or against the death penalty if certain facts are present. They took an oath to say, look, if certain aggravating factors are present, I will vote for the death penalty. That's what the oath says. And if they have that attitude, they were required to recuse themselves from the jury process. And, the judge has a requirement, so the defense attorneys and the prosecutors, to strike them from the panel if a juror indicates during voir dire that they cannot be fair and impartial.
Is there? And we have to take a quick break, so maybe just in 30 seconds, if you can talk about this. But is there a chance somebody had an issue with the familial DNA?
If they did, it was irrelevant, and it should not have been brought. So that was a
Josh,
legal issue.
Hold that thought.
Hold that thought.
Sure.
We're right up against the break.
Okay.
Celeste and I at the exact same second.
Whoa.
We have commercials.
That was a good curveball. It was a good curveball.
Okay.